Greetings of the day. Welcome to IC 57 Fire and Consequential Loss Insurance Chapter 1. Basically, this chapter 1, this this is explaining the terms of fire insurance. Fire insurance, of course, it is a contract, and the various principles from the foundation of the insurance. The principle of insurable interest forms the basis for deciding who can take insurance. Basically, you have come across, you have completed the IC01 principles of insurance. So all these principles are repeated again and again in various subjects because the foundation of insurance is based on various principles. Every subject, every discipline, maybe marine, maybe fire, maybe engineering, we'll be discussing that one. So the basically person should have insurable interest for taking the policy. And then you will also know how the principle of indemnity ensures that the insurance can be used only to shield one from potential loss and not to make profit out of it. Then there is also under insurance. Then there are various different types you should be knowing about it. So you will also learn the principle of subrogation, which will ensure that the insurance company does not suffer losses by paying claims for the mistakes of some other negligent third party. And finally, one also should appreciate why one should disclose all the relevant information at the time of taking insurance policy. There should not be any non-disclosure of material fact at the time of taking policy, because you should not influence negatively or indifferently to the person who is accepting risk from your this thing. And then of course there is the principle of utmost good faith. So all these principles are governing the insurance policy, and you should know about it. So this is the chapter 1 of the IC 57 is covering this, and we will be discussing various things in which is discussed in chapter 1. Basically, the fire insurance business, this has been defined in section 2 of the Insurance Act 1938. What is the definition? It is a business affecting otherwise than incidentally to some other class of insurance business contract of insurance against loss by or incidental to fire or other occurrence customarily included among the risk insured against in fire insurance policies. The subject matter of fire insurance, the subject matter of fire insurance may be any kind of movable and immovable property. Again, try to understand movable and immovable property having pecuniary value, that is financial value of building, furniture, fixtures, fittings, household household articles, contents of plant, equipment and machinery, stocks and merchandise in premises or in open. So this is basically this is referring to the this can be classified into three groups. What are the social perils? The social peril is Royd strike and such other nature. These are social perils. Then there are natural disaster and natural perils. There is a storm, there is a floods. So these are all natural perils. And then there are of course miscellaneous types of peril, that is a aircraft damage, impact damage by road and other vehicles, etc. So the fire insurance contract, as we know, it is governed by the general law of contract as embodied in the Indian Contract Act 1872. And the fire insurance contract must have the following essential ingredients in order to make the enforceable by law. So what are the ingredients? There has to be offer and acceptance. So there will be a proposal form which will be accepted by the insurance company. Then there are considerations. What are consideration? There is a payment of premium. If there is no consideration, there cannot be any claims, no. So subsequently, and then there are agreement between the parties. So what are the agreement? There are standard agreement as per the standard forms in the insurance industry. So there will be a special fire and the special perils policy. Okay, fire policy and special perils policy. Then there is a legal competence of the parties to the contract. So this is also important that, and then legality of the contract. So legality of contract, you have to have the stamp duties, etc. So it becomes a legal contract. So these are the about the fire contract, fire insurance contract. So we should understand the basic principles. Fire insurance is governed by basic principle which has evolved under common law. These are discussed. We have discussed couple of times in every subject. This will be discussed at least once. Be it a fire insurance, marine insurance, machinery breakdown, whatever it is. So in that every chapter, every discipline of insurance, these basic principles are always discussed. So what are the basic principles we are going to discuss? The first thing is utmost good faith. That means there should not be any intention of cheating. There should not be any intention of uh, giving a wrong information at the time of, when somebody is accepting the risk. He should not be giving a wrong picture about the uh, atom which is being insured. So there has to be the material facts about the risk is to be disclosed with the insurance company, and there is utmost good faith. Then there is a principle of indemnity. So I have discussed about the story, Lord Shivaji, he was going and one day wood cutter, his axe is falling in water. And then he was crying, the Shivaji comes, he gives him a gold axe. He's telling, no, this is not my axe. And then he's giving a silver axe. He's telling, no, this is not my axe. And then he is giving his own axe. So he's accepting it. Of course, he was a Lord Shiva. So he's giving all the another two axes to the woodcutter. But then what is the principle of indemnity? You have lost a X, which is a forged steel X, so you should not get a golden X or gold X or silver X. And then whatever there should not be under insurance. So there cannot be under insurance. You see, the idea of principle of indemnity is that you should not be making profit out of the loss. That should not be the idea. And then what is that insurable interest? You should have the insurable interest at the time of taking the particular property, a particular insurance of the property. Without that, you cannot be taking the insurance. Then there is a proximate cause. You see, this is the fire policy, is a named peril policy. The perils covered are listed in the policy. So the proximate cause has to be a nearest cause for the losses, and this is also a governing principle, considering it is a proximate cause of the loss. Then there is a contribution. So if there are two insurances involved in this, there cannot be two policies basically. Okay, I have taken with, say, for example, New India Assurance Company my property for, say, 50 lakhs rupees. I'm also taking the insurance from uh, United India Insurance Company for 50, National again from 50, and the Oriental again 50. So for a property of 50 lakhs, I have taken the insurance of 2 crore rupees. This is not permitted. There will be suppose there is a loss, you cannot get it from all the four insurance company 50, 50, 50, 50. No, that is not allowed. So you can get only 50. So there will be a contribution from all the insurance companies in that case. In life, it's something different. In life, you can have the more. Of course, in life also, for example, a person who is a some manager in one of the bank. Now the manager's salary may be a lakh rupee or something like that. But then if he's taking policy of 100 crore rupees, definitely there has to be intention of some fraud. Okay, and there are many fraudulent claims even in the life insurance policy. So you have to understand these things. Then subrogation. That suppose the loss is caused because of somebody else under a contract and somebody else is responsible for that, then under the letter of subrogation, under the letter of that particular contract, having settled the claim under, so again subrogation, you cannot make profit. You cannot claim from the person who is doing wrong and also from the insurance company. So your authority legal authority to claim from that third party, it is subrogated to insurance company. So these are the basic principles we should understand. Every examination, there would be one or two questions on these particular principles. So let us see the various principles. Utmost good faith. An insurance contract, the legal doctrine of utmost good faith applies. The insured has the duty to disclose all the material facts which have a bearing on the insurance. A breach of this duty may render the contract void or voidable depending upon the nature of the breach. See, it is like this. I have to give all material information about the risk, what I am taking the insurance. Because if you are giving a wrong information and if you are influencing the insurance company to accept the risk and decide the premium based on your inputs, and if that proves out to be wrong, then it is a breach of utmost good faith, and also it is a non-disclosure of material fact which is related to the risk, and then the loss can be awarded by the insurance company. The insurable interest. The requirement of insurable interest gives legal validity to insurance contract and distinguishes them from mere wagers. You see, the insurance, basically you can take the insurance if you have the insurable interest, if you have the financial or direct relation with that asset which you are taking insurance. For example, I have I have a car. I can take insurance of my car, but I cannot take the insurance of my neighbor's car, and then I'll say that if that car is meeting with an accident, I will get the money. Why should I get the money? I don't have any insurable interest. Tomorrow, people will start taking the insurance like this, and they will destroy the vehicle. You see, it is like this, that if I take somebody's life insurance with benefit, if he dies, benefit to me, then there is a every chance that he will be murdered. Well, see, there are many stories on this basis. So, the thing is that when you are taking insurance, you should have direct relation, financial relation with that particular asset or the property what you are taking insurance. The principle of indemnity. The fire insurance are contracts of indemnity. That is, their object is to place the insured as far as possible in the same financial position after a loss as that object was immediately before the loss. Of course, there is a reinstatement policy. Nowadays, the market value of the property has been dispensed with, and then the insurance is taken on a reinstatement value basis. That means I have a house which is 30 years old. When I purchase that house, or you can say that depreciated market value of my house, it is only 25 lakhs rupees. But if I have to reconstruct the house, it is going to be, say, for example, 1 crore rupee. So then I can take the insurance for 1 crore rupee, but then I have to reinstate that one, and then only I can, suppose there is a loss. Then you see what was happening. If I take the insurance of my property which is old, so it is at lesser price. If it is a totally damaged, with the money what I get it from insurance company, I can never reinstate the property because so much of money is not available. So now the insurance company has come up with the reinstatement value based policy, which is given in the fire policy, machinery breakdown policy, and couple of things. In marine, of course, it is not given. For ship, of course, it is not given. Then there is a principle of subrogation. The principle of subrogation, it is a corollary of the principle of indemnity. So that means I cannot take profit from both. I have a contract with this transporter, and now I am getting insurance from insurance company. I will also get from the uh, transporter. This should not happen. If the loss suffered by the insured is recoverable from the third parties who are responsible for the loss, the insured's right of recovery are transferred or subrogated to the insurance company when they indemnify the loss. So having paid the loss to the party, their rights of recovery from the person who is doing wrong is subrogated. So I can sue him, the insurance company can sue him with the letter of subrogation only to the extent of how much they have paid to be insured. Then there is a principle of contribution. the principle of contribution, which is also corollary to the principle of indemnity. You see, you cannot claim from the 2, 3, 4 insurance companies. It is also, as I said, that the indemnity provides that if the same property is insured under the more than one policy, insured cannot recover more than the loss what he has suffered. He can recover only a rate proportionate of the under each policy actual value. That means what I am trying to say, that I cannot take from all the 4 public sector 50, 50, 54 policies of 50 lakh rupees when the value, the reinstatement value is 50 lakh rupees. In case of total loss, I cannot get 2 crore rupees from all the 4 insurance companies. So that means I cannot make profit out of the loss. That is the main principle of the insurance. And to avoid that, there is a principle of contribution which you should know. You see, you can understand the concept of tariff. You just see, earlier when we used to have the ticket booking from the railway window, the railway clerk, the booking clerk, was having a book. So he will take the form for, say, maybe reservation or even normal ticket. So he will ask me, okay, from where you are going? So I am going from Mumbai to Ahmedabad. Then what is the train? Is it a mail, express, or it is a passenger, or shuttle, or different, whatever the time. Then which is the class, first class, second class? Uh, Earlier there was third class, but now it is only second class, first class. But there is a second AC, then there is a first AC, and there is a second AC. So I have to decide. So when I say it is Delhi to Mumbai to Ahmedabad, it is second AC. It is by Gujarat Mail. The book will tell me what is the charges, what is then whether I am the senior citizen, then what is the discount for senior citizen. So this everything is available in the tariff. From tariff, the railway clerk is taking the money for, and then he is issuing the ticket. Online also same things, the same calculation is done computerized. So the fire insurance business, this was governed by All India Fire Tariff, AIFT. The Tariff Advisory Committee, now it is decommissioned, have also laid down rules, regulations, rates. It is not, it is dormant. It is not, it is not decommissioned. So they have laid down rules, regulations, and advantages, terms and conditions for fire insurance business in India under the provision of Part 2B of the Insurance Act 1938 as amended. The tariff is statutorily binding on all the insurers, and any breach of the tariff shall be breach of the Act. The wide provision of the Section 64 UC in bracket 4 and in bracket 5 of the Insurance Act 1938 as amended. The IRDA, after extensive discussion through Advisory Council, withdrew the rating part of the tariff effective from the 1st January 2007. It was also decided that tariff regulations other than those relating rating, respectively clauses, warranties, policy wording, all shall be followed until decided otherwise. So they have D tariff. What is D tariff? Now the ratings can be decided considering the risk individually by the insurance company, and it is not compulsory that the rating has to be as per tariff. So it has been all other terms and conditions, etc. You cannot change that one. You cannot amend that one. That will remain same. The exclusion, the conditions, and the perils which are covered, all things would remain same. There will not be any change. Now you look at the standard fire and special perils policy. That is popularly known as SFSP policy. So this policy basically is consisting of first thing, it is operative clause, then there is a general exclusion, and then there are general conditions. So the standard fire and special peril policy is hereafter referred as the fire policy. The operative clauses, this clause consists of 3 parts: preamble, limitations of sum insured, and perils what is covered under the policy. Then the second is general exclusion. So there are 15 exclusions under the policy which is provided. And then there are general conditions. Again, there are 15 general conditions are provided in the policy. So you as a participant, as a student, note down that you take out the policy copy, keep it with you, read that policy once, majority of your problems will be solved, because that will, and also the tariff is also available on Google. You can extract, maybe I think it is some 50-60 pages, I don't remember exactly, but you can download that one and read that one once, so that will give you a lot of idea when it comes to the fire tariff. Now, you should know what are the perils covered under the special fire policy and special perils. Fire, of course, if there is a fire, losses attributable to fire are covered. Any losses attributable to lightning. There could be fire because of lightning. There could be uh, collapsing of wall because of lightning. Such other damages attributable to lightning are covered. Explosion and implosion is covered. Explosion is what? That is exploding from inside to outside because of pressure is developed. Whereas implosion is because of vacuum and internal you can say vacuum. It is collapse. The pressure vessels, etc. You will find there is an implosion. Then any fall of aircraft or any damages attributable to fall from aircraft are covered. Right strike, malicious damage, and terrorism damages are covered under the policy. Then there is a storm, cyclone, typhoon, then tempest, hurricane, tornado, flood, and inundation. That is the accumulation of water, which is covered. The impact damage is also covered. What is impact damage? I have a compound wall. Some truck comes and hits on that. So that damages are covered. Subsidence and landslide, including rock slide. That yes, my house is at such a place that there is a landslide and there is a rock slide, and then or there is a subsidence. It is it is sitting down. That is covered. The bursting and overflowing of the water tanks. What happened if the tanks are burst and my house is below that? There is a possibility that with bursting and overflowing of tanks, the articles in my house, flat, residence can get damaged. The missile testing operation, any losses attributable to missile testing operations are covered. Now take the example of in Pakistan. Suppose the Indian misfired missile. If they would have damaged something, they would have been a claim under fire policy, that missile testing operation. But then a surveyor like me would have said that it was a misfire and it is not because of any testing operation. The name peril suggests that it is a testing operations are covered, and not the misfire of missile it is covered. And then this is not falling in the purview of the named peril. The sprinklers are provided. If there is a fire and heat generated, there is a automatic water sprinkling system is there. So that sometimes what happens if it is triggered by mistake, or even there is a fire and it is triggered everywhere, it can damage some of the stock and some of the items which is kept. Some of the machinery also can get damaged, and which is covered. The bushfire, of course, bushfire. It is a common in winter, because the hay catches fire, and then it suppose my go down on my open stock, it is just in the foothill of the hill, and then this bushfire approaches up to my warehouse, which is covered. The earthquake related damages are not covered, but it is an add-on cover. When earthquake is excluded, everything which is related to earthquake is excluded. There is a inundation because of earthquake, that also will be excluded, but this is given as a add-on cover. So that you should know. Terrorism damage exclusion warranty, which is provided in the, if it is provided in the policy, then it is excluded. Terrorism damages are excluded. Now you should know about the general exclusions provided in the policy. So there is a excess clause. What is excess? Let's say, for example, up to 0.5% of the sum insured, up to 10,000 rupees, up to 50,000 rupees. So considering the sum insured and considering the losses, there can be excess provided in the insurance policy. So, say for example, if the excess provided is 25,000 rupees, and then if the loss is say 1 lakh rupee, in that case I will be recommending that the net assessed loss is 1 lakh rupee. After uh, see, basically when you are assessing the loss, you have to consider, first uh, depreciation, then there is a salvage value, then there is the under insurance, and after that what we call it DSU, and after that there is a excess provided in the policy. So after DSU, if it is coming 1 lakh rupee as a net loss, and then the excess provided is 25 lakhs, then I will say net assessment is 1 lakh less excess provided is 25,000. So recommendation is 75,000 rupees. So excess is the amount that insured is is a insurer for that particular amount of the loss. It can be varied, either they will give, they are relating the excess with the loss, or it can be in the terms of percentages. The war and alike perils are also not covered under the fire policy. So if there is a bombarding and then with that explosion, if there is a fire in the war-like situation, then the insurance company would not honor that type of claim. Then the nuclear risk is also not covered. Of course, these are things, the war perils and the risk because of nuclear, they are very remote. The risk analysis, if you do, it is 0.0000 or 0.01%, whatever you take it. But the chances are very, very less. And then if there is a suppose nuclear attack, I don't think there would be anybody who can, the claimant will remain, or the insurance company would remain in that particular area. There may not be any claimant at all. Along with the houses, the people would also get, uh, anyway, not to discuss too much on that. Then the loss damage due to pollution. There is a air pollution. Say for example, Taj Mahal is getting, eroded because of pollution. Now your house also can get eroded because of pollution, or there can be a chemical pollution, there can be a acid rains and pollution, there can be a the flue gases and pollution. So such pollution damages are not covered under the policy. Then the loss damage, unless expressly covered, so it is a named peril policy. In named peril policy, if it is not covered under the policy, it will not be. So any peril, so for example, rainwater damages. Now rainwater damages are not covered under the peril. So if my stock is outside, there is no inundation, but it is only merely a rainwater damage, then it is not covered under the named peril, and hence it will not be covered under the policy. So loss and damages which is not expressly covered under the policy, and any that peril is operative, the loss will not be covered and settled by insurance company. Damage to stock due to change of temperature. There is sometimes what happens in the cold storage, what something, there is a sudden change of temperature, there is a failure of refrigeration system, and then these type of stock damages are not covered under the, as it is falling in general exclusion. Then there is a damage due to electrical risk except a spread of fire. What is that? That means if the fire starts because of the short circuiting of electrical equipment, machine, wiring, or something like that, and if it is subsequent, so that particular electrical equipment or wiring will not be covered, but any losses subsequent to that will be covered. So because of any damages, because of whatsoever reason there is a voltage fluctuation, if there is an electrical fire, the intention of insurance company is not to cover that. Then the architectural fee is also covered up to certain percentage. So for example, let us take 3%. So anything more than that, you have to expressly cover in the policy that okay, you have to pay additional premium and get it covered. Similarly, debris removal is also say beyond 1%. If you want to clear, you see nowadays the debris, if my building is costing 1 crore rupees, naturally the removal of debris in case of total loss, it will be much more than 1% of expense. So I can understand, and then you know the what is the cost of removal of debris, and that can be suitably covered under the policy. So then many times what happens that there is a failure of electrical system, and then the with that the temperature cannot be maintained, the refrigeration stops. Now, such spoiler damages are not covered under the policy. Loss by theft, except provided in Roy strikes and malicious damage clause, it is not covered. There could be losses of the theft after the fire, but then it is covered under RSMD. So loss damage due to earthquakes are not covered under the policy, but it is an add-on cover, and if it is not covered, any losses related to, see what happens with earthquake, there is a possibility of inundation also. There is a tsunami. Tsunami is a result of the earthquake. So when such damages are there, the intention is not to cover. It is falling in general exclusion. But if it is covered as an add-on cover, then automatically that exclusion will be deleted from the policy. So loss damage property removed to other places except for the repairs. So other than, see, I am keeping it as storage somewhere else. And if it is not indicated in the floater policy, naturally it is not covered. But if it is going for the repairing purpose, and then naturally then it will be covered under the policy. Now these conditions are very, very important. That non-disclosure of material fact or non-disclosure which is related to the insured risk. If it is non-disclosure, then it is not any misdescription or non-disclosure of any material particulars. This is reiteration of the principle of utmost good faith. Okay. Fall or displacement of the building. So the policy will remain open, or the cover. The insurance under this policy will automatically cease after 7 days from the date of fall or displacement of the building or part thereof. But this will definitely not apply if the displacement is caused by peril insured insurance against. Then material alteration or condition. The change of trade. You see, I am in manufacturing boiler. If I suddenly change into electronics atom, then it is not covered. Then unoccupancy of building, say more than 30 days, it is not covered. The transfer of insurable interest, unless it will be operation of law, it will not be covered. On death of insured, if it is a proprietorship, then also it is not covered. The insurance may be continued if the insured, before the occurrence, if any loss damage obtained, the sanctions on the company through endorsements. That is the thing. Then what is that? The right of entry condition. So under any circumstances, there is a right of entry. The insurance company can enter it and check it and inspect it. So these are things. Anything which is a fraudulent or fraud or false declaration. Again, this is going to the material disclosure, non-disclosure. Then there is the reinstatement of the indemnity. You have to reinstate the damage atom, then only you can claim for the. So you'll have to go for the reinstatement invoices. And if the policy is not, the policy is on reinstatement basis, but actuals, if you see the purchase value and try to find out what is sum insured, if it remains on basis of, say, market value only, then there would be a due depreciation to be deducted. So there is a reinstatement of indemnity. Then second thing, my building is collapsed. It is based on reinstatement value, but the insured, he doesn't want to reinstate it. So then he can claim only the market value, not the reinstatement value. So there is a arbitration condition. In fire policy, there is a condition for arbitration, that instead of going to court, there can be a sole arbitrator, or there can be, it depends, how client wants it and how insurance company wants it. So it can be sole arbitration can be provided. There has to be written notice, etc. for this. This condition is there, and then something if it is insured under marine policy. For example, marine policy, once it is in the transporters go down, it is continued cover is for 7 days. After 7 days in storage in transporters go down, or the port premises, there is an automatic terminal. In port it is 60 days, in airport it is 30 days. So, and then the insurance company, as a belly of cargo, the port, the transporter may take the fire policy as a belly. The the goods held under trust. But firstly, the marine policy will be operative and then the fire policy. If 30 days are over in airport, 60 days are over in port, 7 days are over in transportation, then it is. Uh, and then there is a termination of cover. So there is a specific uh, reasoning for termination of cover. Then there is a duty of assured. You have to try to minimize the loss, promptly try to reinstate, try to don't try to make profit out of it. So basically, what is the duty of insured? The duty of insured is to minimize the loss. Okay, and then there is a uh, termination of cover. This insurance may be terminated at any time by the insured, and premium is refunded at a short period scale of by say company. On 15 days notice, the premium can be refunded. Okay, and then this insurance is also not covering property which at the time of damage insured under marine policy, which I have already discussed about that particular thing. And then the, 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 the condition gives up, and then the pro rata average condition. So what is pro rata average condition? That whenever my sum insured, it is less. For example, the insurance, I have taken insurance of 50 lakhs rupees, but then actual the sum insured, actual the reinstatement value of my property. Of course, land is not. Land will never get damaged because of fire, flood, etc. So it is, you can always delete it from the policy. So the value is 1 crore insured for 50 lakhs and it is in total loss. Then I can get only 50 lakhs rupees. But if it is a partial loss and the repairing charges are 25 lakhs rupees, then I cannot get 25 lakhs because I am under insurance by 50%. So on 25 lakhs rupees sum the repairing, the 12.5 will be self-insurance and 12.5 is passed down to insurance company. So insurance company would pay for it. So then there is a contribution condition. That means if there are 4 places insurance, and then everybody would contribute considering their sum insured and actual value of it. The idea is, this is also can say that this is a principle of indemnity. You cannot make profit out of the loss. Then there is a subrogation condition. What is subrogation? That as per you are also the insured is also under contract with someone, and the losses are sustained because there is a breach of contract, and then it is the loss is triggered under the fire policy. But then considering the contractual obligation, the insured can always claim from the contractor or whoever is the person who did wrong thing. Maybe the neighboring fire has damaged my particular premises, etc. So the insurance company would settle the claim, take a letter of subrogation, that is recovery rights from the third party are subrogated, and then they will pursue the recovery. Again, this is as per the principle of indemnity, that you should not make profit out of it. And then the reinstatement of some insured condition. So what is that? Having settled the claim, I will be paying, I'll have to again top up the premium of the amount of loss what has been suffered by this. So what is this? Uh, the Say for example, my policy is for 1 crore rupee and loss is of 25 lakhs rupees. Having paid that, again I have to pay premium of 25 lakhs rupees. So that is a reinstatement. The sum insured is reinstated under this condition. So let us summarize what we have studied and learned in this particular presentation. Firstly, the subject matter of the insurance, of fire insurance, may be any kind of movable and immovable property. This would be question in MCQ, that what all things covered, movable is covered, immovable is covered, both are covered. So it is movable and immovable property having pecuniary value is covered under the policy. Fire insurance contracts are governed by the General Law of Contract as embodied in the Indian Contract Act 1872. Fire insurance is also governed by basic principles evolved under common law. These include utmost good faith, principle of indemnity, insurable interest, proximate cause, contribution, and subrogation. The sum insured is to be fixed by the insured. You see, he wants to, this can be on reinstatement based policy, so he has to fix the value. So every time you may not be in position to get new value, but then nevertheless you can always find out what is the today's price of the building construction in that particular area. The stamp duty is collected and the valuations are declared, etc. You can get valuation from that, or you can work it out the value considering the latest construction cost in, say for example, Mumbai, Calcutta, Madras, Chennai, or the town where the property is insured, and then the insured will fix the sum insured. The sum insured should represent the actual value of the property insured. If there is a under insurance, if there should not be over insurance. Over insurance with the intention of fraud will not be, the entire claim will be in the problem. Anything which is underinsured at the time of claim, the suitable deduction or condition of average will be applicable, and then there cannot be benefit, the full benefit will not get to, so no claim amount will be proportionately uh, the claim amount will be proportionately reduced considering the applying pro rata average or underinsurance. The fire insurance business, it was governed by All India Fire Tariff. The Tariff Advisory Committee have laid down the rules, regulations, rates and advantages, terms of conditions, fire insurance business in India under the provisions of Part 2B Insurance Act 1938. The fire policy from consists of three main parts. What is that? The policy is having three main sections, we can say: operative clause, general exclusion, and general conditions. You can uh, download any fire policy and you can get acquainted with this. The perils covered generally include fire, lightning, aircraft damage, explosions and implosions, aircraft damage, roids, strikes, terrorism damage, storm, cyclone, hurricanes, tornadoes, bushfire, leakage, bushfire, such other. The perils covered generally include, which we have explained. There are generally 13 exclusions prescribed in the policy, and there are generally 15 conditions prescribed in the policy. So this is the end of chapter 1. Thank you very much. So all the contents of this video are only for general information or use. They do not constitute advice and should not be relied upon in making or refraining from making any decision. In case of any omission or discrepancy, information in the original records will be final and binding. It is also not guaranteed that information in this video is up to date and ultimate. If there is a change of book and change of certain things by IRDA, there would be definitely changes. I have prepared this presentation for education purpose to the best of my knowledge and ability. You see, try to understand. The questions will be asked from the book. So if there is a mistake in the book, you have to follow the mistake. Otherwise, it is programmed in such a way that they will not appreciate if you give correct answer, but then it is not there in the book. Thank you very much. Thank you very much. Thanks.